Dominic read modern history at Magdalen College and graduated from there in 1978. In 1980 he was called to the bar, became Queen's Counsel in 2008, and in 1997 he was elected as Member of Parliament for Beaconsfield, Conservative Member of Parliament for Beaconsfield, and held a number of posts on the opposition front bench during the Labour years. Between 2010 and 2014, Dominic served as Attorney General in the coalition government, and in that role he was an absolutely exemplary figure. The job of the Attorney General is to be senior legal advisor to the government, and in particular to the Prime Minister, and sometimes a government or a Prime Minister needs to hear legal advice that they need to hear rather than legal advice that they want to hear. And Dominic was exemplary in fulfilling that role and in asserting and offering the full support of his office for the rule of law within government, warning on a number of occasions against Britain's withdrawal from the European Court of Human Rights. And if there is a new trend to appoint to that office figures who are less willing or inclined to stand up for the rule of law, then that's a huge shame, and a shame which I think is going to damage our constitution in the years ahead. So I think that the way in which Dominic fulfilled his office as Attorney General is an exemplar, and that makes me even more delighted that he is here tonight. He now serves as chair of the Intelligence and Security Committee of Parliament, which is the parliamentary committee charged with parliamentary oversight of the security and intelligence services, and his election to that post was universally welcomed on all sides. Tonight I think Dominic is going to address the question of Brexit, looking at some constitutional issues and perhaps some human rights issues that might arise from the referendum vote. And he's going to set the scene, and then we're going to open it up for questions and discussion. And we're both very keen, Dominic and I are both very keen, that you become involved in what could become a larger part of the time that we spend together this evening. Dominic has already expressed some views about Brexit. It's well known that he was a leading Remainer within the Conservative Party, and he's expressed some views about the tone of the debate since the referendum. Perhaps as well known as any contribution of his in recent weeks has been his response to the attacks on the judges following the Article 50 judgment, in which a leading newspaper, under photographs of the judges, had a banner headline, "Enemies of the People," pointing out that one of them was, quote, "openly gay," unquote, and in which I think even more shockingly, a member of the cabinet described the judges as thwarting the will of the people. I should have thought a turn of phrase that would have Hobbes turning in his grave. Dominic described these sorts of contributions as being reminiscent of discourse in a fascist state, and I don't think that was an overstatement. I'm delighted he's here, and it gives me very great pleasure to introduce Dominic Grieve.
Thank you, Ken, and thank you very much for the kind invitation to join you this evening, and to try by saying a few words for perhaps 20-25 minutes to set the scene of my own thinking, which has been sort of whirring around in my mind in respect of Brexit. It's rather a difficult issue. I mean, I was Attorney General, and then as some of you will know, I ceased to be Attorney General, and I realised I was turning into a single-issue obsessive on human rights. And when I was addressing an audience a couple of weeks ago, I said, well, I'd finally succeeded in escaping being a single-issue obsessive on human rights, because I decided to become a single-issue obsessive on Brexit instead. It does dominate one's life, rather, and I think that highlights just how enormous the changes that was initiated by the vote on the 23rd of June. As a member of the Church of England, I go to church on a Sunday morning, and one of the prayers we say is we ask that we might be godly and quietly governed. Now, leave God out of it for a moment for the purposes of this evening's discussion, but quiet government we don't have. And I suppose as a rather traditional conservative, I've always been brought up with the idea that we should try to aspire to quiet government. But Brexit has blown that to smithereens. And it seems to me that it can't just be looked at in isolation, because we have to face up to the fact as politicians that it's, I think, part of a wider revolution of resentment, irritation, anger, which is manifesting itself in a lot of strains on our political system at the moment. Just to take a few examples. Human rights. Irritation at our adherence to the European Convention, which I, as a lawyer, happen to think is immensely beneficial for our country, and I'll come back to this a little bit later. Devolution. I think, as a traditional politician, that the unity of the United Kingdom is a very desirable thing. Not that I don't believe that we shouldn't have some devolution. You can have different sorts of structures for a country. But I would be very saddened, partly because I have lots of Scots ancestry, if the union of the United Kingdom were to come to an end. And yet, we have to face up to the fact that we're living in a time where that could happen. And then perhaps the crisis in confidence in our political institutions, highlighted by the expenses scandal, but I think also highlighted by the current explosive quality over the way in which Article 50 should or should not be triggered, whether the state should act as the agent of the will of the people, excluding Parliament from a major constitutional change, or alternatively that in fact Parliament should have a centrality in deciding what our future relationships with the European Union should be. And finally, and as Ken rightly highlighted, the attack on the judiciary which went with it, a quite spectacular explosive moment, which did worry me a lot, particularly because although it wasn't instigated by government, government didn't, in my view, take the necessary steps when it happened in upholding judicial independence and disassociating itself wholly from what was being said. Put forward an argument which said, well, actually, we believe in the independence of the judiciary and the freedom of the press, and giving the impression everything's all right, seemed to me to slightly miss the point when the government itself was a party to the litigation where the newspapers were attacking the judges in such vitriolic terms. And finally, perhaps final point on this introduction, the economic consensus. Well, I think we may have missed this, and I don't want to get too drawn into it. I can't get drawn on everything this evening, but it's interesting that the last couple of years seem to me to see a breakdown in the traditional economic consensus of a liberal democracy as to how we should be governed. I mean, we don't know exactly where it's all going, but Jeremy Corbyn's sort of ideas of letting 1,000 flowers bloom in the Labour Party and going for a form of socialism that has certainly not been present in Labour for 25 or 30 years, coupled, of course, with some of my colleagues in my own party calling for a much more aggressive Singapore-style economic future for the United Kingdom outside of the EU, all these seem to me to be hallmarks of change based on sections of the public showing greater impatience about the governmental system that they have. So my task this evening, in setting the scene, was to try to draw those strands together. I'm not sure I'm going to come up with any very particular solutions, or I might sort of offer myself as Prime Minister of the United Kingdom immediately, and I don't think I'm quite in the market for that. But I did just want to look through a few of them and just consider the implications that went with them. Just want to go back to Brexit to begin with. When I was knocking on the door and trying to understand what it was that was motivating people to vote for Brexit, there's no doubt that there was a multiplicity of issues. Some simply didn't like having an extra sovereign jurisdiction bossing them around, although when you actually asked them what it was they particularly objected to, many couldn't really focus on a specific issue. There's also undoubtedly the issue of immigration, and that those words which I heard repeated on the doorstep all the time about loss of control. A sense that control had to be taken back because without it, the country's destiny was going to be hijacked by others. A very powerful message, and one which I'm afraid the Remain campaign showed itself singularly unable to counter because it reduced itself entirely to sound bites and refused to actually engage with the very issues which were worrying the public in the first place, which I think was a fatal error. Now, all that, I suppose, hinges round a rather traditional British subject, which is parliamentary sovereignty. A lot of people know that there's this thing called parliamentary sovereignty, although I'm not always sure that they know exactly what it is. And indeed, even those people like myself who are supposed to have studied parliamentary sovereignty are not always wholly clear in our minds as to what its limits might be. Taken in its absolute sense, it means that Parliament, provided the Queen were to sign off our legislation, if we decided we would require everybody in this room to worship the moon every Tuesday, we would have the power to do it. Whether you would then decide to worship the moon every Tuesday, I don't know, but I suppose we could include some coercive powers to require you to do it, which of course is exactly what the Act of Supremacy of 1534 under King Henry VIII required the people to do. So it has happened in the past. But I think parliamentary sovereignty as it exists today is a creature of a 17th century conflict between Parliament and the executive. And it's a battle which Parliament won, but the question that was never answered when Parliament won it was the prospect that it was Parliament itself which might be the underminer of people's liberties rather than the executive. Those who drew up the Bill of Rights of 1688-9 thought that only the executive and the king were the enemies of liberty. But of course, actually, the subsequent 300 years have shown rather clearly that there have been times where there have been plenty of individuals or groups who thought that it was Parliament which was the enemy of liberty and its subverter. Just to take a couple of examples, the American colonists in the late 18th century, who were taxed without representation by actions of the UK Parliament, or for that matter the suffragettes, who modelled themselves, of course, on the barons of the Magna Carta of 1215 in defying Parliament, because they said that Parliament, in not giving them the vote, was failing to put right a fundamental wrong. And of course, it's Parliament which enacted the 1972 Act that took us into the EU. And it's Parliament that willed that the 1972 Act should have precedence over United Kingdom law. And, I think it may be of some significance, it was Harold Wilson who thought, possibly because he was of the view that it was such a momentous act, but also partly because he wanted to reconcile differences in the Labour Party, who held the first nationwide referendum to approve what Parliament had done, and had it approved by quite a substantial majority. And all these things, of course, now being called into question over 40 years later. And it is an irony to me, because the first thing that emerges to my mind out of the consequence of Brexit is that far from Brexit being a manifestation of the restoration of parliamentary sovereignty, I begin to think as a parliamentarian that it constitutes the biggest threat to parliamentary sovereignty we've ever experienced in modern times. Firstly, my friends and colleagues in government, who I respect, have decided, as you'll be aware, that the royal prerogative should be used in order to trigger Article 50 and take us out of the EU. Now, when this was first raised, I expressed an open mind as to what the outcome of the court case would be that we'd just had in the High Court. But what I did think was extraordinary was that they wanted to take us out of the EU and invoke Article 50, which we think is irrevocable, without even having an approval vote by the House of Commons and the House of Lords to do it. And I expressed at the time in Parliament my astonishment that we should move to a form of government where a fundamental constitutional law, which is the 1972 Act, should effectively be wafted off the statute book by the means of a Royal Prerogative Act of removing the underpinning treaty base on which it was founded by Parliament. Now, as you'll all be aware, there's now been a challenge in the High Court, and the High Court described the government's position, and I quote, as flawed at a basic level. And it will be interesting to see what the Supreme Court has to say about it. In fairness, the government didn't argue that it could get rid of statute law by use of the Royal Prerogative. It simply argued that it wasn't getting rid of statute law because it was just incidental to a treaty change that it wanted to carry out. But bluntly, I'm not surprised at the High Court's decision, because since the early 17th century, or indeed even since Sir John Fortescue wrote his treatise on the exceptionality of English law in 1453, the idea that a king can, by proclamation, alter the common law of the statute law of the realm has been regarded as an outrageous suggestion. And yet that is what we have ended up arguing for. The 72 Act must be seen as a constitutional act. I have been unable, and at the moment actually I get the impression the government is unable to draw up a list, a full list, of all the legal consequences that currently flow from the 1972 Act. In Thoburn, the Lord Justice Laws described it as one of the most important constitutional statutes that we have, because it not only took us into the EU, but it also meant that a whole raft of legal rights, from intellectual property to data protection, to the ability to move persons and capital around Europe, to voting rights in the European Parliament, to competition and anti-discrimination law, all progressively became rights that we collectively enjoy in this room, not because they were given to us, some of them may have come to us directly from the EU Commission, but in fact the vast majority have come to us by the intermediary of statute law passed by Parliament. So the idea that Parliament can simply wash its hands of this and say that it's going to leave it to the executive to decide which laws should remain seems to me to be starting the Brexit process on a very bad footing indeed. Quite apart from anything else, I don't think it'll work. As you will have noticed, Parliament is deeply divided on the issue of Brexit. I'll be happy to talk about this later, and I don't want to get bogged down into it now. But the reality is that there is almost certainly a majority in the House of Commons which probably didn't want Brexit to happen at all, but accepts that in the light of the referendum result, Brexit has got to be implemented. But that doesn't mean that we wash our hands of what Brexit should mean, and the vote itself did not tell us what sort of Brexit people wanted to have. Indeed, it would have been an impossible question to ask. So we have to pay some attention as a Parliament, if we're going to maintain any credibility with the public at all, as to what it is or what form this should take, and to debate it. The government's response, of course, has been to offer us the Great Repeal Bill. And we are going to have a Great Repeal Bill, although as you'll mostly in this room will be aware, a Great Repeal Bill is not a repeal bill at all. It's an entrenchment bill, taking every bit of European law people can lay their hands on, and saying that on the day we leave, it becomes the law of the United Kingdom, notwithstanding the fact that we've now left the EU. But the best figure we have from the government itself is that we are talking of 40,000 legal acts, 15,000 court decisions and 62,000 uniform standards which apply to the United Kingdom as a result of our 42 years of membership. How on earth are we going to go about disentangling all this? The answer, I suspect, as Lord Judge highlighted in a lecture he gave actually before the Brexit referendum, is that Parliament will be asked to resort to Henry VIII clauses, that is, giving the executive sweeping powers to get rid of anything it likes by statutory instrument, which, as I know from 19 years in Parliament, is the way in which you can almost guarantee that bad law is created. So here too is going to be an enormous task. How do we, in the next 2 years, well, I suppose if we have transitional provisions beyond that, how do we navigate our way through this morass of legislation, much of which is wanted? I've yet to have a single letter from any constituents highlighting something that they want repealed, which I find very remarkable. I mean, when we were in, all those people who wanted the Hoover regulations repealed, the ones which say that so you can't have, you can't have your Hoover setting, a Hoover sold over a setting in order to save energy. I did get a few letters about that, but nobody's raised it with me since we left. I did also notice that the United Kingdom had promoted it as a regulation in the EU at the time it was first created. We and the Danes, as I seem to recall. It was a moment of environmental enthusiasm. But nobody has yet told me what we're supposed to get rid of. And then when we've decided what we're going to retain, the next thing we haven't decided is what we're going to do next. The businesses in my constituency are not interested in, well, I suppose they are interested in some sort of certainty on the day we leave the EU, but what really interests them is how can they continue doing business with the EU on the day after we've left. And for that, we are going to have to consider what rules we wish to be bound by thereafter. Do we want to mirror, by statutory instrument, every decision of the European Court of Justice in those areas where we want to continue trading? I got myself into terribly hot water on the radio about a few weeks ago when I was asked by somebody, but it means at last we leave the jurisdiction of the European Court of Justice. And I said, I don't think we ever will. Because if we're trading with Europe, ECJ decisions are going to continue to have an impact on us. So those people who believe that's what's going to happen have, I'm afraid, been sold a pup. And even if we chose to move, as one or two of my colleagues clearly believe is desirable, to a World Trade Organization relationship, which is being advocated by some of the hard Brexiters, who say we should simply wash our hands of the EU and go, and say we don't want any sort of subsequent treaty relationship of any kind. But if that's what we want to do, we're still going to have to negotiate with 163 WTO members, one of whom actually is the EU itself, to uncouple ourselves from the current relationship where we are embedded with the EU within the WTO and get the other 163 members, including the EU, to agree to the new terms of relationship by which we are in the WTO and our tariff list is agreed. So the WTO isn't a fallback position at all. What it actually is another treaty that we are going to have to negotiate. And then there's devolution. Politically, I have to say to you, and this is a bit heretical, I'm not actually sure that devolution has helped the cause of Scottish independence one little bit. Because ironically, when I go north of the border, the impression I get from people is that the SNP have been presented with some very hard choices. Historically, the SNP have always wanted independence light. That's an independence where you are both in the EU and the UK, rest of the UK is in the EU, and also, I might add, an independence where you can fly off every St Andrew's Day and appear with a benevolent President of the United States on the White House lawn to emphasise your importance. Well, as things stand at the moment, there's no common EU membership, and I don't quite see Nicola Sturgeon jetting off to Washington anytime soon to make herself in a friendly mode with Mr. President Trump. So it's quite a cold world out there. But that doesn't get us away from the legal problems associated with Brexit. Parliament, in its wisdom, has just enacted the 2016 Scotland Act. Now, as a law officer, I will tell you, I'm not allowed to talk about the advice I give to people, but on this occasion I will probably break that rule. Because successive law officers, and Ken will understand this, successive law officers have consistently said that declaratory legislation is a very bad thing. So would somebody in the room please tell me what Section 2 of the Devolution Act, Scotland Act 2016 means? Parliament at Westminster will not normally, Parliament will not normally legislate on devolved matters. Now, I have no idea what normally means, and I have no idea how a court would interpret the word normally if there is a challenge, but we're going to find out soon enough, because I think that is the precise question that the Scottish Government is going to ask the Supreme Court in 10 days' time. Because the implication could well be that as there is a heap of EU law which is in fact devolved to Scotland for its implementation, and on top of that there are laws in place which require the Scottish Parliament to comply with EU law at all times, that we can't actually pull out of the EU or indeed trigger Article 50 either without the consent of the Scottish Parliament, if it indeed has a right to withhold consent, or alternatively by overriding that consent by passing primary legislation to do it. We can do that at Westminster, but I would have thought myself that it was something that no sensible government would particularly wish to provoke in the way of a political spat. And then we have Northern Ireland, where on top of that we have the Belfast Agreement, which underpins a peace settlement which is pretty fragile, and where I keep on hearing colleagues banging on about it doesn't matter, we used to have a common travel area and we can have a common travel area again. But we're not talking about a common travel area, we're talking about a customs union. And if we are not in a customs union with the EU, and Ireland is, which it undoubtedly wishes to be, then it is impossible to see how you can escape all forms of barrier control or checks on goods that cross the Northern Irish-Ireland border. And for that matter, there will have to be some checks on travel as well, because otherwise Ireland will be the way in which the immigration restrictions that my colleagues wish to introduce will be routinely circumvented. It's also rather unclear what happens to the benefits of Irish nationality, which are supposed to be conferred on anybody in Northern Ireland who wants to take advantage of them. Does that include EU citizenship? And if so, what does that mean in the context of living in Northern Ireland, which is no longer part of the EU? And that highlights for me the second theme that I just wanted to touch on this evening before we move to a conversation. And that's about the impact of what we're doing over Brexit on international law and Britain's place in it. When I was Attorney General, I once asked the Foreign Office, because I was going to give a talk on Britain and international trade and finance. I said, could you please tell me how many treaties the United Kingdom is a signatory to? And this sent the Foreign Office law clerks into a complete tailspin. And for about 10 days I pressed them politely to give me an answer. And eventually they came back and they said, Attorney, we're really sorry about this, but we have to tell you that the records, obviously the earliest treaty we have is with the Portuguese in 1360. And so we can't really go back that far, but we're prepared to go back to 1834. And since 1834, we have signed up to 13,500 international treaties, of which over 700 have arbitral mechanisms for resolving disputes over their interpretation. And I think bluntly that the United Kingdom is probably the greatest treaty-making power in world history. Now, why have we done this? Because this isn't the product of the post-war, although I have to say the post-war has played a very major role in increasing treaty-making. The UK was doing this in the heyday of empire in the 1870s and 80s. We did it because it has been an article of political faith and policy of the United Kingdom to believe that international treaties and creating a rules-based system facilitates trade and commerce and prevents armed conflict. Now, you can question that. For example, we went to war in 1914 because actually we honoured a commitment we had under a treaty of guarantee to the Belgians, which the Germans had conveniently decided was merely a scrap of paper. but that does show the amount of importance we attach to them. Indeed, when I was Attorney General, I used to spend a vast amount of my time advising the government on making sure that they observed their international treaties. Indeed, so important it was that in the ministerial code that we had until last year stated categorically that ministers of the Crown and civil servants had to observe the UK's international treaty obligations. Then David Cameron got rid of it, those words, in a fit of pique, I think, of being reminded about them too often over prisoner voting rights and the European Court of Human Rights judgment. But the moment that happened, the Cabinet Office reiterated that the fact it had been taken out of the text made no difference to the fact that that is what the United Kingdom does. And indeed, we are still talking today. I was listening to the Foreign Secretary only a few days ago who was talking about the importance of a rules-based international system in ensuring peace and prosperity. So where does it leave us when we, as a country, decide to pull out of the single most important international treaty to which we are a signatory, the EU treaty, at a time when we've also shown extreme ambivalence towards perhaps the second most important international treaty to which we're a signatory, which is the European Convention on Human Rights and our membership of the Council of Europe, and where, in looking around the world, there is ample evidence that the rules-based system is being increasingly ignored by predatory states like Russia, or for that matter, China. This is a huge challenge. And of course, the UK's position on the ECHR has been invoked by countries like Turkey, the Ukraine, Russia, even countries outside of the European Convention like Kenya, in defying or refusing to observe international obligations. The Venezuelans did it just before they pulled out of the American Convention on Human Rights when they were failing to observe the judgments of the court. It does raise for me very considerable anxiety about where that leaves us in terms of our international status. Why should anybody see us as a reliable partner in forging other treaties, if indeed we seem, rather like a failed marriage, to be unable to maintain relationships within existing treaties? Now, of course, we've pulled out from treaties sometime. We used to be members of the International Labour Organization of the UN, and that became so obsolete and useless we said we were going. Although, interestingly, we still observe some of the agreements that were enacted under it. But that does trouble me, because actually the irony, the supreme irony of Brexit, is that we are going to have to embark on one of the most intense treaty-making processes in recent modern history for our country, because we're going to have to, apparently, to replace the 57 treaties the EU has by way of bilateral agreements with other countries for trade. We're going to have, I think, to have a treaty with the EU itself, or several treaties with the EU we've got to negotiate. And, of course, my colleague Ian Fox wants to run around the world creating free trade agreements with a whole host of states which he believes that the UK will be in a better place to do outside of the EU than inside of it. And yet we're going to start that process by showing our apparent inability to operate within an international-based rules system at all, or to work it to our advantage and accept the rough and the smooth. So that was my survey for this evening. And I was just going to say at the end, what should we do, was probably the next question. As a politician, I don't find the answer very easy. I don't think that we can disregard what the electorate said to us on the 23rd of June. For all the reasons I tried to put into the start of my talk, I think that we sent a very clear message that something in our political system is not working properly. But I do think that we have to be pragmatic. I do think we need to exercise common sense and to avoid ideological positions. And I do think we have to listen and watch what's going on around us, both in Europe and here domestically, if we're to keep options open as to how we get ourselves through this process without damaging the quality of life and economic well-being of British citizens, which is, after all, one of the absolute primary responsibilities of government. and be willing to consider even the possibility, to my mind, that the electorate might change its mind on this subject. But that's not to say that we should be stopping or not implementing what the electorate have told us. And I think the second lesson I derive from all this is that if we are to find a way towards a better system of government, we really do have to start looking in this country, although I have to say to you, I don't think any of my colleagues are willing to do this. We do need to start looking about whether we do not require some constitutional ground rules as to how we conduct our relationships. Because the one thing I think that Brexit shows to me, particularly on the devolution angle, is how uncharted waters are going to lead to potentially catastrophic outcomes if we're not careful. But that requires some political will, and pulling the strands together in the current state of political turmoil is going to be enormously difficult. But it's a challenge which politicians of previous generations have sometimes succeeded in facing up to, so we must just hope that there are politicians in this generation of whatever party who are willing to try to do the same thing and capable of influencing the electorate and gaining their trust in order to do it. And with that, I said I'd talk for half an hour, and I think I have spoken enough. But what I would really welcome, seeing that you have so kindly welcomed me here this evening, is an opportunity to continue this discussion and hear your views. Thank you very much.